Chris Whafoi. Taloha ni.
Taloha ni and tēnā koe, Mr. Chair. Mr. Chair, it's a pleasure to take a call in part 2 of the Legal Assistance Amendment Bill. Mr. Chair, this is an issue that has played quite largely in my electorate of Mana. There was quite a well-attended public meeting around the issue of the access to legal aid, organised by someone who I think knows the Minister and the Chair quite well, and has, I think, lobbied him on many occasions around her concerns around some of the provisions, many of the provisions in this bill. Mr. Chair, pointing directly to part 2, I want to also head towards clause, I think it is 27, that my colleague Andrew Little did, and this is the insertion of some new sections 131A to 131C, and this is around the advocacy for children. Mr. Chair, one submission I did want to highlight during the Select Committee process was from the Children's Commissioner, Dr. Russell Wills, where he had serious concerns about where this bill was heading in terms of looking after children. And in point 21 of the submission that he made to this bill, Dr. Wills said, and I quote, "In addition, I note that the bill makes no reference to the best interests of the child in the explanatory note to the bill, despite the fact that it will clearly impact upon children and young people who are involved in the family or youth court proceedings." He goes on to say that these children and young people are among the most vulnerable in our community, and it is therefore imperative that their interests are given primary consideration. And I think that's quite very interesting. I think is probably one way to put it, but quite a damning statement from the Children's Commissioner, and the fact that this bill hasn't really taken the best interests of children to heart, both within the explanatory note and also within the provisions of this bill. And that was, in essence, Mr. Chair, the substance of the meeting that was held in Porirua. There was a lot of concern from the legal community, from a lot of agencies who deal with children in this situation, about the ability to advocate properly for children in these situations where you have families who are separating. Especially, Mr. Chair, because there is a lot of legal assistance offered in this situation, because a lot of the families that these lawyers are acting for do find themselves in serious hardship. And as Andrew Little did, I just wanted to point towards, I think it is subsection 6 of clause 27 of this bill, and ask if the Minister in the Chair could try and clarify for us the definition of serious hardship as it is in the bill as it stands at the moment, because as it stands, serious hardship in relation to a party or a dependent child of that party, and A1 says includes significant financial difficulties that arise because of the party's inability to meet minimum living expenses according to normal community standards. And for any judge to try and make sense of that, I think will be difficult, because if that judge were to be in the Porirua District Court, Mr. Chair, that would be difficult, because I'd say that most of the families in there would meet that test and would therefore be able to get some kind of compensation or get legal assistance, but some others may not, depending on where they were at the time or whichever court they were being seen in. So, if I could ask of the Minister, of the Chair, if he could clarify that for us, that request coming from both myself and also Andrew Little. But I just did want to make that point just before my 5 minutes is up, is to make the point that we don't believe that the best interests of the children is at heart here. We do believe, if you look at the change in the title, and we'll get plenty of opportunity to debate that. It was originally the Legal Assistance Sustainability Amendment Bill, but that has been changed. But we believe that the real driver of this bill is in the original title of the bill, and that is to make, in the eyes of the government, legal assistance much more sustainable, which in real speak is to cut costs at the detriment of justice and access to justice, and unfortunately, in this case, Mr. Chair, at the detriment to the ability for families to get access to justice for their children in these situations. And that was certainly made clear by the Children's Commissioner. And I just want to read that quote once more to make the point Because he did not, Mr Chair.
The honourable member.
Thank you very much, Mr Chair. In that contribution, in that submission, the Children's Commissioner said that the bill makes no reference to the best interests of the child in the explanatory note, despite the fact that the bill will clearly impact upon children and young people who are involved in the family or youth court. And Mr Chair, that also goes back to the access to justice issue, which I know we've already debated part one, but this is very much related to it, around the fee that some families would have to pay to access legal aid. Now, I understand, and I may stand corrected, that that was originally $100. But I think the select committee process has brought that down to a fee of $50. But I know certainly from the people in my area that they have been saying that if they have someone that comes along and arrives in their reception who they have dealt with in the past, that they have a history, they have a relationship with that family, they are very reluctant to turn them away because they cannot afford to perhaps pay $100 as it originally was, or $50 as it stands now. So what they would do is more than likely accept the case because they know that the family does have a very important case to be heard, and there may be, as I said, there may be children involved, and there are three options that could potentially happen in that situation. The provider will simply just pay that itself and wear the costs. All the clients will end up wearing the costs over that financial period or that financial year if they just aggregate all those fees. Or in the end, the legal provider will just end up slapping another $50 or what potentially could have been $100 on the bill that the Crown gets. Mr Chair, we don't think that is necessarily the cleverest situation to be in, especially when it is asking of a lot of legal firms who are, a lot of them are considering getting out of the legal aid, out of that legal aid arena, to be able to wear the additional costs of getting over the first hurdle for many of these families to access the legal aid. So that was one of the concerns that was certainly raised in the Select Committee by a number of submitters, and again raised by one very strident legal provider in my area who again knows the Minister and the Chair quite well, and I'm sure has had a conversation with him about it. So, Mr Chair, we are concerned around the ability of this bill to look after the best needs of the children. That has been made pretty clear in the quote that I've used twice from the Children's Commissioner, and the ability for families to access legal aid in that situation and for the best advocacy for children. And then on the other side of things, we're also very concerned about the access and, or I guess, some of the barriers that have been put up for access to justice for a lot of families under this bill. Just before I finish off, I just wanted to also say and commend the Select Committee. As I've said, I think in a previous contribution to this bill, I think they've taken what was an awful bill and just made it bad, which is an improvement. Because I think they have taken into consideration some of the submissions that they heard through the process. I guess members on this side of the House have tried to make some changes, and there has been some movement from the government to support changes around that, first of all, their fee from $100 to $50. That is an improvement, but it still, we think, is a hindrance to access to justice. So I guess you have to, I don't want to be too harsh on that Select Committee because they have made some changes that make the bill better, but we still don't think it is a very good bill in terms of making the legal aid arena more efficient and I guess a little bit more sustainable, but also balancing that up against the access to justice and the fairness to justice, especially for those vulnerable families. So I'll leave that there, and hopefully the Minister and the Chair can answer some of those questions, especially around, I think it was that clause 27 in terms of serious hardship, if he could try and explain to the House what the spirit of that clause saying that the party's inability to meet the minimum living expenses according to normal community standards does mean. If the Minister and the Chair could elaborate for us, that would be quite useful for this side of the House. Mr. Chair.
I call the Honourable Minister. Chester Burrows.
Thank you, Mr Chair, and I just want to address 3 points that have been raised by the previous two speakers and put their minds at rest.